I would like to invite Ms. Christy Yu, Senior Solicitor of the Companies Registry, to give the presentation on the anti-money laundering and counter-terrorist financing requirements for trust or company service providers. Ms. Yu, please.
Good afternoon. Thank you for attending this session on AML-CTF requirements for trust or company service providers. In this part, apart from talking about the key requirements, I will also highlight the major legislative amendments recently made to the AML in relation to customer due diligence, which affects TCSP licensees. As you should be aware, with the passage of the Anti-Money Laundering and Counter-Terrorist Financing Amendment Bill 2022 by the Legislative Council on December 7th of last year, the Anti-Money Laundering and Counter-Terrorist Financing Amendment Ordinance 2022 was published in the Gazette on December 16th of last year. AML Amendment Ordinance enhances Hong Kong's regulatory regime for combating money laundering and terrorist financing. While the main changes are to bring the virtual asset service providers and dealers in precious metals and stones within the anti-money laundering and counter-terrorist financing regime, taking the opportunity of amending the AML, certain miscellaneous amendments were made to the AML to address some technical issues identified in the FATF Mutual Evaluation Report and other contexts, including better align the definition of beneficial owner in relation to a trust under the AML with that of controlling person under the Inland Revenue Ordinance. Also amending the definition of politically exposed person, PEP, and introducing the concept of former PEP to allow the exemption of enhanced customer due diligence requirements in respect of former PEPs on a risk-sensitive basis. Further, providing for the use of digital identification systems as recognized means to mitigate risks in situations where a customer is not physically present for customer identification and verification purposes. I will go into details shortly. The amended ordinance has come into effect in phases in the second quarter this year. The registration regime for dealers in precious metals and stones took effect on April 1st of this year, whereas the licensing regime for virtual asset service providers, as well as other relevant amendments to the AML-CTF requirements under the AML affecting TCSP licensees, among others, have taken effect on the 1st of June this year. As mentioned by Ms. Leung just now, the CR, the Companies Registries, as a regulator of the TCSP sector, has updated the AML-CTF guideline for TCSPs in the light of the changes introduced by the amendment ordinance. Some other updates have also been made to the guideline to address certain other gaps identified in the Hong Kong's mutual evaluation, to ensure that Hong Kong can achieve technical compliance with the FATF recommendations. Also, FAQs, commonly asked questions, have been posted in our TCSP registry's website to provide further guidance. Now, first, I will quickly remind you of the key customer due diligence and record-keeping requirements and highlight the updated requirements. When TCSP licensees carry out a transaction concerning a trust or company service for a client by way of business, they are required to carry out CDD measures under the AMNO. As you can see here, Section 3 of Schedule 2 of the AMNO set out when TCSP licensees should carry out CDD measures. Please note, in particular, that licensees should carry out CDD before establishing a business relationship with the customer. For example, before they act as a company secretary for a new customer. The customer due diligence measures under Section 2 of Schedule 2 to the AMNO are set out in this slide. Licensees are required to identify the customer and verify the customer's identity. For the second CDD measure, that is, identifying the beneficial owner and taking reasonable measures to verify the beneficial owner's identity, I would like to draw your attention to the legislative amendment in relation to the definition of beneficial owner in relation to a trust under the AMNO. As explained in the Legislative Council brief, the objective of amending the definition of beneficial owner in relation to a trust under the AMNO is to align it with that of controlling person under the Inland Revenue Ordinance, which implements the common reporting standard promulgated by the Organization for Economic Cooperation and Development. The amended definition of beneficial owner in relation to a trust under the AMNO will also be in line with the FATF recommendations and other jurisdictions which have implemented these international requirements. Specifically, the definition of beneficial owner was amended to clarify that where a trust is concerned, it includes trustees, beneficiaries, and classes of beneficiaries. So, as you can see in this slide, in the definition of beneficial owners in Schedule 2 to the AMNO, in relation to a trust, the phrase, an individual who is more than 25% of the capital of was removed, and a beneficiary or a class of beneficiaries of the trust and a trustee of the trust are added. All right, let's go back to the CDD requirements in general. You should check whether the information and documents required in the applicable appendix of the guideline have been obtained. For example, in this case, as the customer is a corporation, then the licensee should identify and verify the corporation and obtain information and documents in accordance with Appendix B of the AML guideline, which is applicable when the customer is a corporation, such as obtaining a copy of the Certificate of Incorporation, Articles of Association, details of the ownership and control structure of the company, and a list showing all directors of the corporations. The licensee should identify the beneficial owner of the customer and take reasonable measures to verify the beneficial owner's identity. As the beneficial owner of the corporate customer is an individual, the licensee should collect the information and documents set out in Appendix A of the AML guideline, such as obtaining a copy of the beneficial owner's Hong Kong identity card. Please don't forget that where there is a person purporting to act on behalf of the customer, that person's identity has to be identified and verified as well. Licensees should obtain written authority, including board resolution or similar written authority in case the customers are corporations, to verify that the individual purporting to represent the customer is authorized to do so. Insofar as intermediaries are concerned, please check our website for the FAQ we have recently posted on CDD regarding carrying out CDD by means of intermediaries. Subject to the requirements set out in Section 18 of Schedule 2 to the AMNO, you may carry out CDD measures required under the AMNO by means of an intermediary specified in Section 18, Subsection 3 of Schedule 2. However, the ultimate responsibility for ensuring that CDD requirements are met remains with you. Please note the conditions under Section 18, Subsection 1 of Schedule 2 for reliance on intermediaries to carry out CDD measures, including that the intermediary consents in writing to be your intermediary. Specified intermediaries in Hong Kong are listed out in Section 18, Subsection 3A and B of Schedule 2 to the AMNO as shown in this slide. That is, an accounting professional, an estate agent, a legal professional, and a TCSP licensee, provided that they are able to satisfy you that they have adequate procedures in place to prevent money laundering and terrorist financing, and are required to comply with the requirements set out in Schedule 2 to the AMNO with respect to customers. Also, another category is a financial institution that is an authorized institution, a licensed corporation, an authorized insurer, a licensed individual insurance agent, a licensed insurance agency, and a licensed insurance broker company. For provisions in relation to specified intermediaries in an equivalent jurisdiction, please refer to Section 18, Subsection 3C of Schedule 2 to the AMNO. The intermediary should be subject to CDD and record-keeping requirements in line with the AMNO, and be regulated, supervised, or monitored. It is not the case that any unregulated entity can do so. Please refer to paragraphs 5.53 to 5.60 and the text boxes under paragraph 5.60 of the guideline for further information. This slide sets out the situation when the TCSP licensee is required to carry out CDD measures for pre-existing customer. That is, those with whom the business relationship with the licensee was established before the 1st of March 2018. For example, where a transaction which is unusual or suspicious, and when the licensee suspects that the customer is involved in money laundering or terrorist financing. TCSP licensees is required to continue to monitor the business relationship with the customer, whether the customer is a new or pre-existing customer, including by reviewing from time to time documents, data, and information relating to the customer to ensure that those information and documents are up to date and relevant. Situations in which TCSP licensees are required to take additional measures or EDD are as follows. Where the customer is not physically present for identification purposes under Section 9 of Schedule 2 to the AMNO, and where the customer or the beneficial owner of the customer is a politically exposed person under Section 10 of Schedule 2, and in any situation specified by the registrar in a notice given to the TCSP licensee, and in any situation that by its nature may present a high risk of money laundering or terrorist financing under Section 15 of Schedule 2. For instance, applying enhanced measures or countermeasures called for by the FATF to business relationships and transactions with natural and legal persons from jurisdictions for which this is called for by the FATF. As I have mentioned earlier, legislative amendments have been made in relation to PEPs. To implement the FATF recommendations and relevant FATF guidance, the definition of politically exposed person under the AMNO is amended from one entrusted with a prominent public function in a place outside the People's Republic of China to one entrusted with such a function in a place outside Hong Kong. As you can see in this slide, People's Republic of China in the definition of politically exposed person under Schedule 2 is amended to Hong Kong. With these amendments, enhanced CDD measures under Sections 10, Subsection 1 and Subsection 2, and enhanced ongoing monitoring under Section 5, Subsection 3b of Schedule 2 to the AMNO applies not only to a PEP from a place outside China, but also a PEP from other parts of China outside Hong Kong. Secondly, a definition of former politically exposed person is added to Section 1 of Part 1 of Schedule 2 to the AMNO, which is set out in this slide. Sections 5 and 10 of Schedule 2 to the AMNO are amended. As you can see in the slides, Sections 10, Subsection 3 and Section 5, Subsection 5 are added so that enhanced CDD under Sections 10 and enhanced ongoing monitoring under Section 5, Subsection 3b of Schedule 2 to the AMNO may not be required for former PEP who are no longer entrusted with a prominent public function, if the licensee is satisfied that the former PEP does not present a high risk of money laundering or terrorist financing based on an appropriate risk assessment, allowing licensees to take a risk-sensitive approach in determining if enhanced measures need to be applied. Please refer to paragraph 5.33 to 5.44 of the AML guideline for further guidance on PEPs, on PEPs, including the definitions of different types of PEPs, that is, non-Hong Kong PEPs, former non-Hong Kong PEP, Hong Kong PEP, international organization PEP, and the CDD measures for various types of PEPs and also the treatment of different types of former PEPs. Please note that we have recently posted an FAQ on CDD regarding the situation when a customer of a TCSP licensee has not been physically present for identification purposes. In addition to complying with the CDD and ongoing monitoring requirements, licensees are required to take additional measures under Section 9 of Schedule 2 to the AMNO. For example, taking supplementary measures to verify information relating to the customer that you have obtained. You should consider to mitigate money laundering and terrorist financing risk by obtaining copies of documents that have been certified by a suitable certifier. Please refer to Section 9 of Schedule 2 to the AMNO and paragraphs 5.29 to 5.32 and the text box under paragraph 5.32 of the AML guideline for further guidance. Also, in monitoring the business relationship with that customer, the licensee should take additional measures to compensate for any money laundering or terrorist financing risk that may be caused by the fact that the customer has not been physically present for identification purposes. Please refer to Section 5, Subsection 3A and Subsection 4 of Schedule 2 to the AMNO and paragraph 6.6 of the guideline for further guidance. Legislative amendments have been made to Sections 5 and 9 of Schedule 2 to the AMNO. As you can see in the slides, Sections 9 subsection 2 and Section 5 subsection 4 are added. As a result, if the CDD requirements are met using a recognized digital identification system, that is, where the licensee has carried out the measure referred to in Section 2, Subsection 1A of Schedule 2 in relation to the customer on the basis of data or information provided by a recognized digital identification system, the enhanced CDD requirements under Section 9, Subsection 1, and enhanced ongoing monitoring under Section 5, Subsection 3A of Schedule 2 to the AMNO are not required. This change is in line with the FATF's acceptance of digital identification systems as effective means to lower the money laundering or terrorist financing risk associated with a customer not physically present. You may wonder, what is a recognized digital identification system? Recognized digital identification system means, in relation to a TCSP licensee, a digital identification system that is a reasonable and independent source that is recognized by the Registrar of Companies. As we have received questions on what digital identification system is recognized by the Registrar, we have included a FAQ to address the commonly asked questions in relation to the Anti-Money Laundering and Counter-Terrorist Financing Amendment Ordinance 2022 to inform you that the Registrar recognizes IamSmart, developed and operated by the HKSAR government, as a digital identification system that can be used for identity identity verification of natural persons. Another part of Schedule 2 is on the record-keeping requirement. The key requirements for the records of transactions and the records of customers to be kept and the duration of keeping such records are set out in this slide. And I think you should be familiar with them by now. Don't worry even if the records are not kept in hard copy, as long as the records are kept in a computer database, which is allowed under Section 21 of Schedule 2 to the AMLO. Legislative amendment has also been made to state that the record-keeping period of 5 years also apply to occasional transaction. Every year, we will remind you of the other AML-CTF statutory requirements apart from those required under the AMLO. In relation to financial sanction, it is prohibited by the relevant regulations under the United Nations Sanctions Ordinance to make available to or deal with economic assets of individuals or entities designated by the UN Security Council, as well as individuals or entities acting on behalf of or at the direction of or owned or controlled by designated individuals and entities. The term economic assets means any funds or other financial assets or economic resources. The most up-to-date list of sanctioned persons and entities are available at the website of the CR's Trust and Company Service Providers Licensing Regime, as well as at the website of the Commerce and Economic Development Bureau. For terrorist financing, the United Nations Anti-Terrorism Measures Ordinance criminalizes the provision or collection of property and making any property or financial or related services available to terrorists or terrorist associates. Please do not establish business relationship or conduct transactions with any individuals or entities subject to financial sanctions or any terrorist or terrorist associate. Licensees should ensure that they have an appropriate system to conduct name checks against the updated lists. Apart from screening customers against current lists of terrorist and sanctioned destinations at the establishment of the relationship, thereafter, as soon as practicable after the new lists of terrorist and sanctioned destinations are published, licensees have to screen their entire client base against the new lists. Please refer to Chapter 8 of our AML guideline for more details. At the UN level, to combat financing of proliferation of weapons of mass destruction, known as PF, the United Nations Security Council has implemented sanctions against 2 countries. Such targeted financial sanctions are implemented in Hong Kong by 2 regulations under the United Nations Sanctions Ordinance, as shown in this slide. Please note that it is an offense under Section 4 of the Weapons of Mass Destruction Control of Provision of Services Ordinance to provide any service to another person where he believes or suspects on reasonable grounds that those services may be connected to PF, including, for example, the lending of money or other provision of financial assistance. Mr. Joey Tan of the Commerce and Economic Development Bureau will give a presentation on risk assessment and mitigation in relation to PF later this afternoon. For reporting suspicious transactions, the relevant legislations are set out in this slide. Mr. Michael Yeung of the Hong Kong Police Force will give a presentation on the methods of money laundering and terrorist financing and suspicious transaction reporting in the next session. This is the end of my presentation. May I now pass the time to Mr. Yeung. Thank you.